check. Not good. You cannot connect.
You can just listen. Is it coming out in the screen? Is the voice coming out?
Let me check.
Are we good?
No, it's showing you.
The mic is getting the mic now, right? The mic. Hello, hello, 1 2, hello, 1 2, 1 2. Hello, 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 hello.
The mic is fine. Is the live stream
Is the live streaming you are testing?
testing?
Okay, fine, fine. Because sometimes the mic will just increase itself.
Take that flower away from that place.
This one.
Yes, sir.
These things have to be taken from Peter. Look for where to go and hide it. Wait it at the back. These bags, all these things have to leave. Okay. Later, no, later. Because they are going to pass here.
Yeah, good. Maybe the voice is coming out. It's okay.
It's coming out, Abby. Everything is fine. We are bringing them in.
Say you know
We just use time.
How you should do the ones, not the bad ones? Just give it to him. This anyways, just give everything.
this mic is normal.
And also, you're here to give battery.
I don't know. Maybe the new audio here or something. I don't know. It's not picking it out. So what is causing this? The audio out from the mixer is not coming to the system.
Okay, the audio is not entering.
No.
Oh, put it on this one. This one instead of this.
But do you have these two audio jacks? I think I'm going to use camera out.
What camera you do?
But that is not going to be very clean. That's just
You see that? Getting this to work. Where is Peter? Please let me get it. So there is.
Hello. Hello.
I think we were not getting the right outlet.
I don't know if you tried using this.
When you tried using this one, it was still sounding like a surround sound. It was not getting the direct.
Let me tell you.
Your voice is coming out.
It's not picking mixer sound itself. It's camera sound. It is supposed to pick the audio from the mixer. Maybe we'll just go ahead with it.
Oh yeah, say something.
Hello. Hello.
It's going to go for the good food. Everything is tasting. Such a shit. Not picking the sound. So we should try this. I think this one should be easier to this ping. Eh? Let me use the mic. Put the mic on. Put it on. What's all those snapping like this? I don't want to see. Alpha. Okay, can we run the, while we are waiting, can we run that video? It's on YouTube. Just check. Just go to
issue. These are some
and on the west by the Democratic Republic of Gobi. The capital of the Republic of Adera is Jongola, and the country operates a presidential system of government.
Contestants are set. While we are trying to do the final touches for the preparation to commence the final rounds, we have the video version of the hypothetical case. So those that are joining us for the first time or they have been following partially, they might not have read the whole facts. So here we have the facts in a video format, and we're going to be playing that for the next couple of minutes before we pass it on. So enjoy.
They are already going to turn. So
Yeah.
what you're saying, I don't know how it's going to play out because they are already entering.
Yeah.
So
We want them to set up.
they can be doing that because they are already turning. Please, just like yesterday, you have to maintain decorum. And those of you who are there, they are coming in court.
Temple of Justice, and as in African Field of Excellencies, is S.E. Atero, lead counsel for the applicant. And apparently with me is A.O. Ajelia, co-counsel for the applicant. Together we are now appearances counsel for the applicant. Your Lordship, Your Excellencies, as the lead counsel, I shall be addressing the preliminary issues as well as the first and second substantive issue before the final report. The applicant has still 4 issues for determination. Whether the Republic of Nigeria's withdrawal of the Article 34 sub 6 declaration is invalid as it violates the African Charter and on the second issue, whether the Republic of Nigeria violated human rights instruments by failing to protect the Beshi people and child workers from the QHL issue. Whether the Republic of Nigeria's withdrawal of its Article 34 sub 6 declaration is invalid. And the third issue, whether the Republic of Nigeria's Public Order Act violates international human rights law. And the last issue, whether the Republic of Nigeria violated human rights instruments through the treatment of Mr. Jude and Mr. Marcos and other protesters, including the use of lethal force, violation of assembly rights, and their conviction and sentence. Your Excellencies, moving on to the preliminary issue before us today, which is jurisdiction and admissibility. The applicant firmly averse before this honorable court that it is clothed with the requisite jurisdiction to entertain and decide this instar case. Pursuant to Article 3 sub 1 of the Protocol to the African Charter on Human and People's Rights, which states that the court has the jurisdiction to hear and determine matters concerning the interpretation and application of relevant human rights instruments ratified by the concern. Your Excellencies, the court has reaffirmed this position in the case of the Democratic Republic of Congo and Republic of Rwanda, whose citation at page 9 of the applicant's memorial, where it was stated that whenever an applicant alleges the violation of human rights protocol protected by the Charter or by any other human rights instrument to which the state concerned is a party. Furthermore, in the matter of Tembo, Mooting, and United Republic of Tanzania, at page 9 of the applicant's memorial, it states or the court practically affirms the jurisdiction insofar as applicant alleges a violation of rights protected by the Charter, then that court has the jurisdiction to hear the matter. Your Excellency, given that the subject matter of this suit falls squarely within the domain of human rights violations, the applicant humbly submits to the jurisdiction of this honorable court. On the issue of admissibility of application by the court is provided for in Article 10, Article D, paragraph I and II of the Supplementary Protocol 2025, which implies 3 criteria for an application to be admissible. 1. The status of the applicant as a victim of human rights violations must be established. 2. The application shall not be anonymous. And 3. The application shall not be instituted in another international court of adjudication. However, Your Excellencies, it is crucial to see this on this honorable court of justice that the court has expanded the scope of admissibility to a more liberal approach on the first criterion. The court in the case of registered trustees of Faculty of Peace Organization and Federal Republic of Nigeria, whose citation at page 10 of the applicant's memorial, the court notes that it now recognizes the right of legal entities to bring action for the violation of any human right when brought in a representative capacity on behalf of individual victims. Your Excellency, same with the case of registered trustees of the state.
The applicants have the right to bring this application.
Very well, Your
What is
Excellency.
the status of the applicant?
Your Excellency, can you phrase that?
What is the status of the applicant? Does it have an observer status?
Very well, Your Excellency. Pursuant to observer status is like a limited form of participation. However, when a particular NGO bring a case or whenever a state has ratified Article 34 or sub 6 of the court protocol, has already ratified that particular treaty, then the NGO in that case is already given the ability for the NGO to bring case or even individuals. And pursuant to the statement of fact, paragraph 4, it stipulates that the Republic of Nigeria has duly ratified international treaties as part of their national law, Your Excellency.
Then if I may ask a question, what do you do with the withdrawal of declaration by the state of Nigeria?
Your Excellency, the applicant is only here to say that that withdrawal is invalid.
What does Article 34 say?
Article 34 of 6 states that it states that at the time of ratification of this protocol, or any time thereafter, the state shall make a declaration accepting the competence of the court to receive cases under Article 5 sub 3. However, Your Excellency, Article 34 sub 7 make provision as to as to how this withdrawal can be valid. And the respondent, the Republic of Nigeria, did not, Your Excellency, did not follow this criteria or the requirements. Pursuant to the statement of fact.
Where is this? Which part?
Your Excellency, Article 29, Article 29 sub 9, 7 and 8 said that on 15th of 2025, President Sikorosa announced that Edera has withdrawn its declaration in accordance with the African Court Protocol. May announcement, Your Excellency, and states that may announcement does not validate a valid withdrawal.
Does the state not have a right to withdraw?
The state has the right to withdraw. However, according to section Article 34 sub 7, it has a criteria that must follow. That it must be written, it must be signed by a competent authority, and also transmit copies to the chairperson of the African Commission. However, the respondent in this case did neither of this criteria, which makes it invalid, Your Excellency.
Is that not an assumption that they did nothing like that?
The statement of fact for us stipulates that the president merely announced, which shows that the criteria was not followed, because announcement does not validate the withdrawal.
I heard you cite the case of registered
Assistant Trustee of Peace Organizations and Federal Republic of Nigeria, correct? Is that case before the African Court or before the ECOWAS Court?
The African Court of Human and People's Rights.
Are you sure?
Very well, Your Excellency.
Okay, can you give me the reference?
Registered trustees of a court, the citation.
Yes.
So this is the reason. Zoom out. So open this. My final zoom out.
Registered trustees of a court of peace organization and 3 others and Federal Republic of Nigeria, AFCNRB, R 2015-258. Very well, Excellency. Your Excellency, we will report to the report that this court has the right to admit or to admit our case. On the first substantive issue for the
direct access.
Very well, Your Excellency. Welcome to paragraph 4, paragraph 29 of the statement of fact. It reviewed that Mr. Marcos and Mr. Jim was given a 3-year prison sentence without the possibility of a fine, and the Court of Appeal on the August of 1125 all the same. And pursuant to Article 4 of that statement of fact, it says that the Supreme Court shall not have the right to hear matter that has a case or a fine of less than 5 years. Given that this matter is not more than 5 years, then the Supreme Court cannot entertain that matter, which clearly signifies that all local remedies have been exhausted.
Now, can you have said that the state did not follow the proper requirements. Is that your only reason?
Not only that, Your Excellency.
Yes.
As even without even conceding that this withdrawal is even valid, we still stand on the grounds that even when a valid withdrawal is made, you cannot have a retrospective effect. This means that Article paragraph 29 of the statement of fact reviewed that this the applicant was in talks with the victims to present a case to the African Court on August 12, 2025. And in 3 days after, Your Excellency, this same president announced that he would withdraw this protocol. So as if without even considering that in fact this withdrawal is valid, we're still stating that it cannot have a retrospective effect relying on the case of inaugurated.
Despite the fact that the case has not been filed, they still have 12 days.
The fact states that the applicant is to present a case in the African court. The fact is silent as to whether or not we, in fact, initiated this case. But he stated that yes, we wanted to present a case, and then 3 days after, the president announced that the withdrawal is
before your presentation.
After our presentation.
Is that really a case of retrospective application, or maybe you want to classify or conceptualize it? Because if there is just an intention to file, application is nothing. There is really nothing that the withdrawal affects. Or if you probably want to argue on some other ground as to the effectiveness of the withdrawal, refer to statement.
Your Excellency, the applicant is saying that to allow an irregular withdrawal would amount to an arbitral denial of justice, contrary to Article 7 of Article 1, paragraph A, and 26 of the African Charter, which guarantees the right to be heard and independence of judicial bodies. So, in the light of the foregoing, the proposed withdrawal by the Republic of Nigeria is invalid, unlawful, and of no legal effect.
And at what time will it be valid?
It follows the procedures provided for in Article 34 sub 7, that it must be written, signed by the proper competent authority, as well as deposited to the chairperson of the commission.
There is no issue as to timeline and validity, where I say withdraws.
Not that the commission stipulates.
Okay.
Very good. So, having answered questions based on the first issue that states that whether the Republic of Nigeria's withdrawal Article 34 sub 6 declaration is invalid as it violates the African Charter and other relevant human rights, right, the questions already state or proceed our grounds before this Honorable Court of Justice. So we're going to move on to the second substantive issue, which is that Nigeria violated the African Charter and other relevant human rights by failing to ensure that the Beshi people and child workers are protected from violations committed by the QHL. As a
by trying to relocate them?
The relocation, Your Excellency, is not, according to the of fact, is not something that the people that are living here wanted. So it was like, you're going against their
want or what is good for them?
Your Excellency, the statement of fact reveal that these people have been staying in that residence for years. And even the fact that you want to, you want to just take away their rights to, because every citizen has the right to own a property, every citizen has the right to acquire a land. So even if you want to do something like that, there should have been proper measures as that effect. However, the statement of fact only proceeds that this QHL in question went against every other child rights that these people might in fact have.
And again, my need to answer the question. Extraction of mineral resources enhances economic growth and prosperity of the country. And if, as said by the Lord, there is a provision, an alternative housing opportunity afforded to the people, whereby they will be relocated, don't you think it should be considered? Because the nation must survive, and they need every extraction to remain affordable.
Your Excellency, paragraph 9 of the statement of facts states, he said, in 2018, QHL began intensive diamond mining in the Bashi local government area on the ancestral lands of the Bashi tribe. And this Bashi tribe involves about 240,000 people, of which 2/3 are pastoralists living in the most remote part of Nigeria, which shows that these Bashi people have been living there for years. Over 240,000 people. Your Excellency, I disagree that even the respondents have in fact measures to make over 240,000 people to live in another place. Your Excellency.
Okay, in your view, what will satisfy or correctly or adequately take care of the rights of the Bashi people? What steps do you think the government should have taken? Or under no circumstances, can they not take away the land from them?
There are circumstances that you can take away land from it. However, Your Excellency, when the land involves local population, like I stated, 240,000 people in a land that they've been living over years, and even the government of fact really notes that this is their source of livelihood, which shows that these people have been living for years, doing lots of things, and no answer of compensation, Your Excellency, can satisfy or fulfill over 240,000 people, Your Excellency. So, as a prelude, it's pertinent to remind this Honorable Court of its long-standing decision as it relates to state responsibility under international law, that when a state is a party to international human rights and they are responsible for the violation of the rights of citizens by any conduct of its organs, then such governmental organ shall be held responsible as the state. Your Excellency, accordingly, in view of that certain fact, it is submitted that the act of QHL having constituted multiple violations of human rights.
Is the time up?
She has 9 seconds left.
Multiple human rights violations are attributable to the government. To elucidate this issue, we subdivided into 3 points. It is the primary duty of the state to respect. I'll say that's the point, just get 2 more minutes around. It is the primary duty of the state to respect and protect human rights. The use of force and forced eviction violates the right to life, dignity, property, and health under the African Charter. And lastly, the exploitation of child workers violates both the African Charter and other relevant human rights instruments. The cases of the sections of African Charter on Human and People's Rights, Socio-Economic Rights Action Center, SERAC, and Nigeria, Article 4, Article 5, Article 14, Article 16, Article 18, sub 1 of this charter were all infringed upon by this particular respondent, the Republic of Nigeria. And also as it relates to child workers, Article 15 of the African Charter guarantees the right to work under equitable and satisfactory conditions. Similarly, Article 18 sub 3 requires the state to protect the rights of the child as stipulated in the International Declaration and Convention. By allowing QHL to employ and even expose these children to hazardous conditions, Your Excellency, Nigeria has failed in its duty to protect the children from exploitation. Similarly, Article 24 of the ICCPR recognizes the right of every child to measure by or protection the state, and even the same, similarly, in case of Sarah Nigeria, school citation at page 18 of the applicant's memorial, has shown that the state has failed completely in all of these subdivided issues that we state. They fail to protect the citizens, they fail to protect the children, and even the forceful eviction, pursuant to the statement of facts before us, shows that the QHL, a state organ, which by extension the state is liable to respond to the Republic of Nigeria, has failed in all of these, Your Excellencies. So we are stating the applicant is unbelieved before the court, and the result of the first issue as well as the second issue in favor of the applicant.
Finally, are human rights absolute?
No, they are not absolute, for instance.
Okay.
They are situations that might be put in place for them to. They are not absolute, that is, there are conditions where you can.
So let me rephrase my earlier question. In this case, under what circumstances can those rights be limited?
So let me address that. So look at paragraph 10 of the they were moved. Some families refused to move. Would you consider that as an unreasonable reaction by the family,
Yes,
especially in relation to the measures by the state to resettle this community?
Your Excellency, the applicant is still stating that it's not enough, like these people did not receive enough compensation as the effect of this, the act of the QHL.
Where is that?
Your Excellency.
Where is that? And what is your measure, back to my brother's question, what is your measure of enough compensation?
Your Excellency, compensation can happen in different ways. If these people were given enough housing facilities for over 240,000 people. However, Your Excellency, the fact is silent as to whether or not all of these people were satisfied. And there's a matter that states expression unis est exclusion ulterior, which means the expression of one thing is the exclusion of another thing not mentioned. The fact that they mentioned 240,000 people and they said only certain or few people were satisfied does still not satisfy the entire 240,000 people in Bashi tribe. So we are saying that there are better measures, better compensation that can actually be offered to these people. And even if those compensation were in fact enough, we are very certain that our clients would succumb.
Is it about the compensation being enough for what the state can afford? I mean, can you compel the state to, provide compensation beyond its capacity?
Your Excellency, just like you earlier stated, you said it's for the economy, like it is for the economy of the state to grow. So if the state wants to in fact work on something that has to improve the economy, and they do not have other things in place to satisfy those things that are going to be discomforting, Your Excellency, it's not proportionate.
And assuming not what was provided by the state were not just sufficient, how do you justify that the fact that some families refused to move even when they were provided? Apparently, it shows that there are certain provisions made and that were not utilized. How do you justify that?
Your Excellency, so what are we saying that these people have the right to own lands, right? And even if they say people want to move, there are better options, there are better ways to convince these people to move. Probably negotiation, let's have a meeting one-on-one, let's talk about the implications of all of these things.
You have come here to state that there have been violations on the rights of this nation. Now, on the second protest, we find that they took to the streets just by merely hearing or believing that there was a telephone conversation or something, without any evidence proving that. And then they took to the streets and they started disrupting activities. And they think that that is okay. That is the second protest. Paragraph 27. Blocking traffic, disrupting activities, and they state this based on the fact that they thought the president
not just the voice note that they heard, or perhaps the recordings that they heard, but they were fighting against all of those things that they've actually been facing. First of
The
the first
Minister
protest.
of Lands and Resources was telling his girlfriends in a voice message posted on social media that they wanted to purchase the land. This led to the second protest. Was that reasonable in the circumstances for them to come on the streets, block traffic, disrupt activities of other citizens?
Your Excellency, this other council would further buttress this point on the third and fourth issue when it comes into on council solo request.
Thank you.
Respondents, council?
As earlier introduced by the lead counsel, Able Ajenia, co-counsel for the applicants, and counsel shall address the court on the merit of issue 3 and issue 4 for a period of 10 minutes. On issue 3, which was whether or not the Public Order Act of the Republic of Nigeria violates international human rights law, the applicant assertively contends that the Public Order Act of the Republic of Nigeria violates international human rights law. Section 13 of the Public Order Act requests that protesters are required to obtain permission from the Office of the Inspector General 14 days before the protest. We argue that this action constitutes an unjustifiable restriction to the right to peaceful assembly, thereby violating the provisions of international instruments already ratified by the Republic of Nigeria. These provisions have been guaranteed in several international treaties. Article 11 of the African Charter of the Human and People's Rights, Article 21 of the International Covenant of Civil and Political Rights, Article 8 of the African Charter of the Rights and Welfare of the Child, and even Article 23 of the Universal Declaration of Human Rights. Your Excellencies, bear in mind that all of these instruments have been ratified by the Republic of Nigeria. Article 1 of the African Charter imposes both positive and negative rights, obligations, and state parties. The positive obligation is that states must act to protect the rights of the citizens, and the negative obligation is that states must act and refrain from actions that intervenes with the rights of their citizens, actions that threatens the rights of their citizens. While the right to peaceful assembly is not absolute, any restriction must comply with the tripartite test of legality, legitimacy, and necessity in a democratic society. Your Excellency, the impugn provision not only imposes an impermissible prior authorization regime, but also fails to meet the requirements of proportionality. Thus, reaching the goal.
Can we not agree that the reason for the requirement for permission is to ensure that the other citizens are protected whilst this protest is going on?
While I believe that that could be a reason, we argue that that reason is not valid enough because the right to peaceful assembly is a constitutional provision. A 14 days prior notice is unreasonably long, and relying on the provisions of paragraph 66 of the guidelines of freedom of association and assembly in Africa, where state enact laws on freedom of assembly, those laws shall aim primarily at the facilitation of the enjoyment of this right. Paragraph 71 additionally states that participating in an organizing assembly is a right and not a privilege, and thus its exercise does not require authorization from the state. Inasmuch as the state wants to provide...
Council, look at paragraph 2.
Paragraph 2.
These guidelines that you saw a reference points, do they feature in all the conventions, instruments?
Excellency, I cannot.
The guidelines on freedom of
Association and assembly in Africa, yes.
are they part of
The instruments.
ratified by Nigeria? And if they are not, by what means should Nigeria comply with the guidelines?
Your Excellency, Nigeria already ratified the African Charter on people's rights and on human rights, and the guideline is an extension of the African Charter, providing detailed explanation of on how those rights can be enforced.
So what is from where does the guideline go?
What is the next?
What's the article?
Yes.
What's the article in the charter?
The article in the Charter.
Yeah.
Okay, so what the applicants is relying on is Article 11 of the African Charter that guarantees the right to peaceful assembly. Now, Protocol 71 on the guidelines of freedom, association, and assembly in Africa. The protocol that further elongates the provision of Article 11 of the African Charter. Before I'll be relying on that, whatever right that must be enjoyed in a practical manner. And such rights must be such that does not require authorization or permission.
So, who elongated Article? What the nexus? By what authority is the elongation done?
Your Excellency, the guidelines of the freedom of association and assembly in Africa is to prove and show before the
Who did it?
Who did it?
Who elaborated that article of the African Charter through the guideline?
Is it the Secretariat of the African Commission?
Is it the courts? Is it the African Commission, for instance?
It's a guideline. It's a guideline
by
that was
who?
Adopted by the African Charter, Your Excellency. Yes, Your Excellency.
Okay. Please,
go ahead.
Thank you very much, Your Excellency. Paragraph 71 of the guidelines provides that participating in and organizing assembly is a right and not a privilege, and thus the exercise does not require prior authorization of the state. Also, when there is a failure to notify, the assembly is not to be automatically penalized through disposal. It is indisputable from the provisions of the Public Order Act imposes a limitation to the exercise of the right to assembly, requiring that not only must the Inspector General of Police be notified 14 days prior to the protest, but also he must authorize such protest. This cannot be said to be legitimate, necessary, or even proportional to the intended objectives or accepted limitations as established in the guidelines and in the African Charter on Human and People's Rights, as affirmed by the Honorable Court in the case of Issa Pandi and Burkina Faso. When such requirements are not met, the right of assembly is considered to be violated. Your Excellencies, in light of the foregoing, the applicant submits that Section 13 of the Public Order Act is inconsistent with the respondent's international obligations by conditioning the exercise of the right to peaceful assembly on prior authorization from the Inspector General of Police and imposing an unreasonably long 14-day period. The respondent has enacted a measure that is neither lawful, necessary, nor proportionate. The imputed provisions transforms a fundamental right into a privilege, which is not supposed to be. Every citizen of Nigeria is entitled to the right to freedom of assembly, and the state is not supposed to strip them of this right. Applicants also
is the right to peaceful assembly not subject to law?
The right to peaceful assembly is subject. Is the right to peaceful assembly not subject to law?
Yes. The exercise of it, is it not subject to law of the country?
The right to peaceful assembly is not absolute. However, the right to peaceful assembly takes more cognizance over every other law because the right has been ratified in the Constitution of the Republic of Nigeria, and the Constitution is the frontier of the ground of every nation, automatically supersedes the provisions of the Public Order Act, Your Excellency.
Public order is to maintain safety and security.
Yes, Your Excellency. Your Excellency, Council is proving to this court that without the unreasonably long 14-day period, public order, public safety, and security of every other citizen of the ground would have still been ensured. You don't need to impose a 14 days long period and a need for permission before you guarantee the safety of all the citizens. If the government has provided sufficient security forces during the protest, this would have not been the case. But the same government who was supposed to protect their citizens by the one firing tear gas, when they were shooting their citizens. Your Excellency. Your Excellency, 14 days.
And to just buttress the law, is the 14 days not to give the state sufficient time to make preparations to provide security for both the protesters as well as non-protesters and the citizens?
Your Excellency, according to the statement of facts, the citizens of the Republic of Nigeria informed the state, notified to the general public, and they were going to embark on a protest. Your Excellency, that will not be sufficient to give the state enough time to prepare for the protest. That is sufficient. They informed the state that we're going to protest on the 21st of August. 3 days after the information, the Inspector General of Police came to state provisions of the Public Order Act. If the state truly wanted to provide provisions to cater for every citizen during the protest, they would have done that rather than them objecting to the protest.
The citizens, individuals are entitled to dictate or stipulate their own timeline, different from what is provided in the law of the land.
Excellency, they have the right to do so because the Constitution allows them. It is the right to peaceful assembly.
Won't you say that the Public Order Act, to borrow your phrase, is an elaboration of the right guaranteed under their Constitution?
The Public Order Act
provide a framework for the effective exercise of that right.
Why I agree to that, Excellency, the provisions of the Public Order Act is not supposed to contradict the provisions of the Constitution. The Constitution is the foundation upon which the Public Order Act
is. Is it contradicting it?
It's contradicting it.
How?
Exactly. The Constitution guarantees every that their right to peaceful assembly and their right to protest, and this right is not to be challenged by authorization or permission. And the Public Order Act is saying, no, the International Convention says this, and the Constitution already ratified this International Convention, relying on the provisions of paragraph 4 of the Statement of Facts. Now, the Public Order Act is saying that for you to come and exercise your right, you must first ask for permission from the Inspector General of Police. That's right.
Looking at the paragraph 27 of the Statement of Facts, would you not say that the whole essence was seeking, asking that there should be permission and authorization? It's actually what happened here where TALs took over and there was a breakdown of law and order. Is that not what is meant to be protected, the rights of the citizens?
Excellency, the government of the state has supposed.
What do you have to say about paragraph 27?
I understand the Excellency about paragraph 27. It's never turned violent because the police, that's paragraph 4. It's never turned violent because the police who had been sent to use tear gas to disperse the protesters were unable to handle it.
Don't stop there.
The government sent police
officers. 5 police officers were
gravely injured by the attack. Yes, and the final line of that paragraph says that 30 people were gravely hurt and 5 civilians lost their lives too. Excellencies, we're saying that the measures of the state and the government was not proportionate. Your Excellency, if I inform the state of my protest, it is the responsibility of the state to ensure that measures are put to place to ensure that my protest is as peaceful as possible.
And because you did not seek proper authorization, the police could not act as they should. And this totally went out of order, and this happened, and people died.
Excellency, this is not the case in the scenario, in the situation before us. They notified the public that they were going to embark.
This is the second protest I'm talking about.
Your Excellency, they're still informed. They staged the protest in the capital. Your Excellencies,
they did not inform the police in this instance.
Your Excellency,
they took law into their hand.
Is Your Excellency saying that that justifies the use of weapons against the citizens because they did not notify them of protest?
Tear gas.
The police should not disperse the citizens with tear gas. Tear gas in itself is hurtful.
So what should they disperse this crowd?
In a functioning society, the police would have provided sufficient security to regulate the activities of the protest. Police officers cannot do it.
Yes.
I want to give a practical situation where that issue that work. The police officers would have been available at protest, direct their movement. In as much as they have right to peaceful protest, you're not supposed to interrupt the rights of the other. That's the freedom of movement. Ensure if the police officer has cooperated from the first protest, provide sufficient security to control their movement. All that will happen would have not happened. Excellency, the police officers are supposed to be active. Notifications have been made regarding the protest. We don't need to act like notification to save lives.
Finally, from me, won't you say the state has the right to disperse and, kind of quench the protest because it has become violent?
Excellency, again, the statement of fact shows us that the 2 protests got violent when the police officer involved themselves. So the state was not interfering to disperse the protest. The first is paragraph 13, paragraph 12 of the statement of fact, which states that the protests were peaceful with protesters carrying placards and chanting solidarity song. However, when some policemen deployed to the protest area started shooting tear gas to disperse the protesters, some touts, otherwise called area boys, retaliated, not the protesters. Some touts. Your Excellency, several students of Nigeria were also attacked on their way home. Bear in mind that they were no longer at the protest. Mr. Frederick did not go to protest. Mr. Gabriel in paragraph 16 did not go to protest. Stories was at home when she expressed all of the dangers that happened from the protest. In paragraph 27 again, the statement of fact informed us that situation was, it's given the fact that the situation turned violent because the police, who has been sent to the
Number one, I would wish that you situate your argument to your claim or to your relief. Paragraph 30D, you say public order act of the army violates international human rights law. I thought you argued that it violates the constitutional provision.
No, Excellency, I don't.
No, that's number one question. Then number two, which international human rights law does the public order act violate? That's another question. Then the last one, I will because the ROE has ratified the International Covenant on Civil and Political Rights. Have you considered what Article 21 of that covenant says? Because specifically, yes, the covenant says that it will be restricted, but then it has to be based on the law, conformity with the law, and the law that is acceptable in a democratic society. Have you been able to understand that?
Yes, Excellency. On the first standpoint, we are saying that the actions of the Public Order Act in itself contravenes the provisions of international law. The Constitution was included because I was trying to prove that the Constitution supersedes the Public Order Act. And since the International Convention has been ratified in the Constitution, as stated in the statement of fact, we can conclude, in fact, everyone can conclude that that provision of the international human rights law is part of the law of the citizens of the Republic of Edera, and as such, the citizens and the government are bound by that law. So yes, the Public Order Act contravenes the provisions of the international human rights law. The international human rights law that has been ratified in the Constitution of the Republic of Edera. And the second question, Excellency, I would like you to retrace the question.
The question is, what particular international law are you talking about? What article of the law? If it violates, direct us so that we can look at it.
Article 11 of the African Charter on Human and People's Rights, which guarantees that every party has a right to peaceful assembly. Article 21 of the International Convention of Civil and Political Rights, and even Article 20 of the Universal Declaration of Human Rights, Your Excellencies.
Right.
Excellency, my time is over. I'd like to speak because you have 2 minutes now to address the final issue. Thank you very much, Your Excellency. On the final issue, which was on whether or not there are violated the African Charter and other relevant human rights instruments, and the various treatments meted out of Mr. Jude and Mr. Marcos, again, the applicant contends that their actions truly violated the right of Mr. Jude and Mr. Marcos. For it in an operation, this argument was divided into 2 standpoints. 1, and the right to liberty and security as privileged, and 2, and the right to expression as also privileged. On the first one, right to liberty and security, Article 6 of the African Charter and Article 9 of the International Convention of Civil and Political Rights guarantee that no one shall be subjected to arbitrary arrest or detention. The actions of the respondents by arbitrarily arresting Mr. Jude and Mr. Marcos constitutes a violation of this provision. In the case of African Commission on Human and People's Rights and Libya, the court expressly prohibited arbitrary arrest, establishing that the lawful nature of the arrest or detention is not sufficient to justify a claim of violation, Your Excellencies. And using the above established law to this present case, the arrest and subsequent detention of Mr. Marcos and Mr. Jude by armed special forces is undeniably a case of arbitrary arrest. The imprisonment of Mr. Jude and Mr. Marcos, though following the National Court conviction, constitutes an arbitrary deprivation of liberty under Article 6 of the Charter, because the judicial process in itself was filled with failure denial of justice. On the second standpoint, that the right to expression of opinion has also been raised. The convictions and subsequent imprisonment of Mr. Jude and Mr. Marcos, who are offence arising from a public protest, constitute an unlawful restriction on Article 9 sub 2 of the African Charter, which affirms that the right to express and disseminate opinions. This right is further amplified by Article 19 of the International Convention of Civil and Political Rights. Your Excellency, the applicant relies on the case of Lowe, East Africa, and Burkina Faso, where the court established that any restriction on this right must be lawful, necessary, and proportionate to the objective means pursued. In this situation, the restriction was not lawful, neither was it proportionate, neither was it necessary. In conclusion, Your Excellency, In conclusion, Your Excellencies, we pray that this court rules in our favor, and we pray that this court adopts all prayers stated in page 24, in page 26, 27, 28, 29, and page 30 of the memorials of the High Council so submits.
Thank you.
Wait.
Your Excellency. Your Excellency, with your kind permission, may I proceed to the issues of jurisdiction? Proceed. Much obliged, Your Excellency. On the issues of jurisdiction, it is our humble submission that the application. Apology to Your Excellency. It is our humble submission that this honorable court lacks jurisdiction over this present application. Your Excellency, the court's jurisdiction is standing on four legs: material jurisdiction, temporal jurisdiction, personal jurisdiction, and territorial jurisdiction. And we submit that this honorable court lacks material, temporal, and personal jurisdiction. On material jurisdiction, by virtue of Article 3, subsection 1 of the Protocol to the Charter, this court's material jurisdiction extends to human rights issues, Your Excellency. And Your Excellency, one of the issues that was raised, that is challenging the validity of the withdrawal of Article 34, subsection 6, Your Excellency, is not a human rights question, but a matter of state sovereignty, as it was affirmed in the case of Femi Falana versus African Union, that the withdrawal of Article 34, subsection 6 of the Protocol, Your Excellency, does not amount to human rights violation, thus falling outside the court's material jurisdiction. On personal jurisdiction, we submit that this honorable court lacks personal jurisdiction, as the applicant's NGO lacks local standing by virtue of the withdrawal of Article 34, subsection 6 of the Protocol, Your Excellency. And in the case of Amnesty International versus Rwanda, this honorable court affirmed that once the withdrawal of Article 34, subsection 6 has been deposited, individuals and NGO lack direct access to this honorable court. Your Excellency, on temporal jurisdiction, this application was filed after the President has deposited the withdrawal of Article 34, subsection 6 of the Protocol, and we submit that this falls outside the court's temporal jurisdiction, because at the time...
Is that a fact before this court?
Yes, Your Excellency, as seen in paragraph 29 and paragraph 30 of the fact of case, the President withdrew this declaration on August 15, 2025, and the application filed by this honorable court was on August 22, 2025, Your Excellency.
The effective date the withdrawal takes effect?
Your Excellency, there is no provision.
Immediate or within a year?
Your Excellency, there is no provision in the African Charter that stipulates a time limit, Your Excellency. So far as it has been done in line with due process, Your Excellency.
Can you repeat the paragraph of the compromise?
Your Excellency, in paragraph 29 of the fact of the case.
Mr. Judah, Mr. Marcos?
No, paragraph 29 of the fact of the case, line 7, Your Excellency.
That says President announced that Edera had withdrawn his declaration in accordance with an announcement. You said the withdrawal, the instrument of withdrawal was deposited where?
Your Excellency, we would like to rely on the presumption of regularity that official acts have been done in line with due process, Your Excellency. That the President has deposited the withdrawal with the relevant officials of the African Union, Your Excellency.
You are assuming.
We like to rely on the presumption of regularity, Your
You are
Excellency.
presuming.
Yes, Your Excellency. Much obliged, Your Excellency. To sum it up, in the case of Anodo versus Tanzania, it was held that these 4 types of jurisdiction has to be met, and we submit that since only one, which is territorial jurisdiction, that has been satisfied, this honorable court lacks jurisdiction to entertain this application. With your kind permission, Your Excellency, the Vienna Convention of Law of Treaties is of persuasive authority to this honorable court. It is not binding upon this court, Your Excellency.
And what is that provision of that convention? What did you say? The relevant provision of the law of treaties convention?
It provides 12 months notice, Your Excellency.
Provides for what?
12 months notice before a withdrawal can be deposited. Your Excellency, with your kind permission, may I proceed to the issues of our
Should that not be considered as a guide on
Your,
when and how it should be done?
Much obliged, Your Excellency. Your Excellency, we submit that this honorable court, when it comes to adjudicating a matter, we submit that if this provision would cause harshness or frustrate state sovereignty, where a state has validly exercised the right to withdraw this declaration, Your Excellency.
In good faith or in bad faith?
Your Excellency.
Cases to be filed within 3 days.
Your Excellency.
From the treaty. Midway, you do not want to fulfill obligations of the treaty. Will that not be considered to be a bad faith?
Much obliged, Your Excellency. Your Excellency, Your Excellency, we submit that the President did not withdraw this declaration in bad faith because, Your Excellency, as in paragraph 2 of the facts of the case, IDERA is a member of the United Nations, Your Excellency, African Union and ECOWAS Treaty, and we submit that this honorable court is not the only way in which these people can get relief they are seeking for, Your Excellency. So we submit that it was not done in bad faith or in obstruction of justice, Your Excellency.
Can I ask you this? Assuming it's a pending matter under Article 34.6, is it permissible or is it allowed for a withdrawal when you already have a matter pending?
Your Excellency, concerning this fact of the case, Your Excellency, the application was filed after the withdrawal and it was not.
That's not my question. I'm just asking you an hypothetical. Is it allowed for a state to withdraw at that point? When the case is already pending, because one of the arguments is that you already have the intention. Yes, the intention is yet to be consummated. But the question is, assuming it's been filed, would you have still withdrawn?
No, Your Excellency. Much obliged, Your Excellency. With your kind permission, may I proceed to the issues of administration? Your Excellency, it is our humble submission that the application brought before this honorable court is inadmissible, subject to Rules 40 of the Rules of the Court and Article 56 of the African Charter, that provides for certain criteria that must be met before a matter can be admissible before this honorable court, which include exhaustion of local remedies, identification of author, amongst many others. And we submit that 3 out of these criteria have not been satisfied. On exhaustion of local remedies, Article 56, subsection 5 requires that all domestic remedies must have been exhausted before bringing a matter before this honorable court. And in the case of African Commission versus Kenya, Your Excellency, it was this honorable court affirmed that local courts must first be given the opportunity to remedy violations before international recourse is sought. Your Excellency, Mapoa had already filed a case before the High Court and it was held in 2024, and which the Court of Appeal reviewed this decision on May 1st, 2025, Your Excellency. However, they failed to appeal to the Supreme Court before bringing a matter before this honorable court.
And why did they fail? Could they appeal to the Supreme Court?
Yes, Your Excellency, because the Mapoa case is a civil case, Your Excellency, and not a criminal case. Your Excellency, concerning the conviction of Mr. Jude and Mr. Marcos, Your Excellency, the matter was held in the High Court and the Court of Appeal upheld the conviction on August 11, 2025. However, they failed to exhaust other local remedies. Your Excellency, although as stated,
was any fine?
Your Excellency, they were guilty for willfully destroying government property in accordance to Section 18 of the Nigerian Criminal Act. Your Excellency? No, without an option of defining, Your Excellency. Your Excellency, although the Nigerian Constitution provides that the Supreme Court's criminal jurisdiction extends to appeal from 5 years sentences or more, we submit that the Supreme Court also has original jurisdiction to determine the constitutional compatibility of legislation, which Mr. Jude and Mr. Marcus failed to exhaust, an extraordinary legal remedy, Your Excellency. Concerning the withdrawal of Article 34, Subsection 6 and the compatibility of the Public Order Act, the applicant's NGO failed to bring the matter before the local court of Idera, before presenting this application before the Honorable Court, and we submit that they failed to exhaust domestic remedies. Your Excellency, on identification of author, Article 56, Subsection 1 requires that the author of communication must be identified. But however, this application, as seen in paragraph 30 of the fact of the case, was filed by EHRD, and the alleged victims were not individually identified, thus failing to meet this requirement. Concerning the compatibility of the applicant charter as stipulated in Article 56, Subsection 2, Your Excellency, the challenging the withdrawal of Article 34, Subsection 6 declaration is not a human rights question, Your Excellency, but a matter of political issue about state sovereignty, as it was affirmed in the case of Femi Falana versus African Union. Your Excellency, to sum it up, in the case of Chacha versus Tanzania, this Honorable Court held that this requirement, Your Excellency, are cumulative, that is to say, not one must be missing, Your Excellency. And we submit that since 3 out of these requirements are missing, the matter brought before this Honorable Court is inadmissible, Your Excellency. Your Excellency, with your kind permission, may I proceed to issues 1? Much obliged, Your Excellency. On issues 1, it is our humble submission that the withdrawal of Article 34, Subsection 6 declaration, Your Excellency, does not violate the African Charter or other relevant human rights instruments, and it does not affect the vested rights of Nigerians. Your Excellency, Article 34, Subsection 6 of the protocol requires states to make declaration accepting the competence of this Honorable Court to receive cases from individuals and NGOs. Your Excellency, we submit that this is a sovereign choice, Your Excellency, not a binding or permanent obligation. It is not an irrevocable treaty commitment, Your Excellency, as it was affirmed in the case of Osao versus Benin, that this declaration, Your Excellency, is a voluntary act of consent and not a permanent or binding obligation, and therefore, Your Excellency, it may be withdrawn. Similarly, in the case of Unagbiwe Umwaza versus Rwanda, it was stipulated that it was held by this Honorable Court, Your Excellency, that declaration is an act that is separable from the protocol, Your Excellency, and therefore may be withdrawn. And this is what the President did in paragraph 29 of the fact of the case. He validly exercised the sovereign rights to withdraw this declaration. And there is no provision in the African Charter, Your Excellency, that prohibits withdrawal. So we submit that the action taken by the President is valid. Your Excellency, concerning the action taken by the President.
Where there is where the provision is silent as to withdraw, should you not have the court to Vienna Convention?
Your Excellency, the Vienna Convention applies to withdrawal of treaty, but in this case, what the President did was to withdraw a declaration and not a treaty. It continues to be bounded by the African Charter, Your Excellency. So the President did not withdraw the treaty, he only withdrew the declaration of Article 34, Subsection 6 of the Protocol, Your Excellency. May I proceed, Your Excellency? Your Excellency, although Section 17 of the Nigerian Constitution requires parliamentary approval before ratifying a treaty that affects the vested rights of Nigerians, Your Excellency, this provision strictly applies to ratification and not withdrawal of a declaration, Your Excellency. And as in paragraph 29 of the fact of the case, the President did not withdraw a declaration. We did not ratify a new treaty, Your Excellency, but withdrew a declaration, Your Excellency. And in Article 46 of the Vienna Convention of Law of Treaty, it provides that an internal law shall only invalidate an international act in cases where the breach is manifest or concerns a fundamental rule. Your Excellency, there is no place in the fact of the case that stipulates that Section 17 of the Nigerian Constitution was violated or parliamentary approval was required before a declaration, withdrawal of a declaration can be deposited, Your Excellency. Concerning violation of human rights obligation, Your Excellency, the withdrawal of Article 34, Subsection 6 declaration does not amount to violation of human rights obligation, as it was affirmed in the case of Femi Falana versus African Union. And also, Your Excellency, the withdrawal of this declaration does not amount to withdrawal of international obligation, because Idera continues to be bounded by the African Charter, the the ECOWAS treaties, the ISECA, and amongst many others. Your Excellency, countries like Tanzania, Benin, and Rwanda, they've withdrawn this declaration, Your Excellency, and this shows that states have the sovereign prerogative or sovereign power to withdraw this declaration. Accordingly, Your Excellency, it is our humble submission that the withdrawal of Article 34, Section 6 declaration, Your Excellency, is valid. It does not violate the African Charter or other relevant human rights instruments, Your Excellency, and it does not affect the vested rights of adherents. Your Excellency, with your kind permission, may I proceed to issues 2? Much obliged, Your Excellency. On issues 2, it is our humble submission that Republic of Idera do not violate the African Charter or other relevant human rights instruments, but has taken lawful, administrative, and effective steps in addressing the violation against the Bashi community. And Your Excellency, with respect to the alleged child labor, we submit that no violation occurred, Your Excellency. Your Excellency, Article 1 of the African Charter requires states to adopt legislative or other measures to give effect to charter rights. And contrary to the applicant's submission, Your Excellency, we submit that IDERA has fulfilled this obligation, Your Excellency. Your Excellency,
allowing children to work in mine.
Your Excellency, as in paragraph 20 of the fact of the case, this report where these allegations of child labor was documented by truth defenders, Your Excellency, and IDERA Mining Board, the government official responsible for monitoring mining activities in IDERA, conducted due diligence, Your Excellency, and this investigation were deemed unsubstantiated, Your Excellency, officially rejecting it as business. And Your Excellency,
The government.
Yes, Your Excellency. No, Your Excellency, they conducted due diligence, Your Excellency, and the report was not backed up by evidence. Your Excellency, in the case of African Commission versus Libya, Your Excellency, it was stipulated by this honorable court that this honorable court should not rely on NGO reports that is not backed up by credible evidence, Your Excellency. Your Excellency, we submit that this is an unsubstantiated report, Your Excellency. Your Excellency, IDERA Mining Board conducted due diligence and investigation, Your Excellency, as in paragraph 20 of the facts of the case, Your Excellency, and we submit, Your Excellency, that there was no child labor or violation of child rights, Your Excellency.
But it is not stated that it is not.
Your Excellency, this report, as seen in paragraph 20 of the fact of the case, according to series of publication by truth defenders, Your Excellency, this is publication, Your Excellency. It is not backed by credible evidence, and we submit that we can't rely on this, Your Excellency, because IDERA Mining Board has conducted due diligence into this allegation, Your Excellency.
So you prefer your own report to that of an independent board?
Your Excellency, despite the fact that this NGO happens on indicative status, Your Excellency, we submit that we can't rely on it as a legitimate source of evidence, Your Excellency.
Okay, so which evidence can you rely on? Which source will you trust?
Your Excellency, we are choosing to rely on the investigation conducted by IDERA Mining Board, Your Excellency.
So you want to be a judge in your own case?
Or better put, can you tell this court what in practical terms have been put in place by your government to ensure sustainable development of your mineral resources? Because the accusation here, they are quite huge. Situations whereby people have been livelihood of people have been taken away from them, and if you have done that, then it's as good as having taken life out of them. Degradation and a lot of other things, and the fact that, yes, you might say it's an NGO report, but whichever way there is no disputation, you have not challenged this in any practical terms, that you did not use underage as child labor. So these are issues. Then the question is this: what have you done as a government to ensure that all of these were not in place, or all of this should not be in place?
Your Excellency, concerning the violations against the Bashi Committee, as seen in paragraph 7 of the fact of the case, the state established an inquiry known as the Jacob Jeffrey Commission to investigate into this police misconduct, Your Excellency, and recommend reforms as in paragraph 17 of the fact of the case, and in line with Article 3 of the African Charter that calls on states to institutionalize a culture that promotes accountability, transparency, and integrity. The public officers, Mr. Bernard, Your Excellency, and Mr. Triplet were dismissed, and similarly, Your Excellency, the police rules of engagement were amended and QHL's operation were suspended until proper resettlement procedures and the introduction of a safer mining technique, Your Excellency. And Your Excellency, in Article... Your Excellency, I would like to plead the indulgence of this honorable court for additional 2 minutes to conclude on this question. Thank you, Your Excellency. Your Excellency, with a GDP per capita of $500 and mining contributing 30% of the national budget, as in the paragraph 3 of the fact of the case, completely halting mining would have crippled down the economy. Yes, Republic of Idera did not sacrifice human rights for profit. It implemented all the JJCR's recommendations. And as seen in the case of Jawara versus the Gambia, it was held that a state is only responsible where it fails to take remedial action. And we submit that Idera has taken lawful, administrative, and effective measures in addressing the violations against the Bashi community. And with respect to the alleged child labor, Your Excellency, we are still standing on the ground that no violation occurred.
Maybe you have left this out. The argument of the applicant is that in your course of extracting mineral resources, you have externalized the costs on the people. They are bearing the brunt instead of you internalizing it. So the argument is not that it does not enhance prosperity. You can go ahead, exploit as much as you want to. The question now is this: should we continue to place the costs on the people, or should the people continue to bear the cost of your extractions?
Your Excellency, we submit that. Your Excellency, please can you rephrase the question?
As it is, their complaint is that you externalize the cost of extraction of mineral resources. You got that?
Yes, Your Excellency.
Then the question is this: should you not take necessary steps to internalize it so that the people will no longer bear the brunt of your extraction?
Your Excellency, thank you for the question. Your Excellency, we submit that Idera has taken reasonable steps, Your Excellency, such as relocation of some of these Mapua community, Your Excellency, and also some of them refuse to evacuate, Your Excellency, and we submit that even though, Your Excellency, we submit that Idera has taken lawful steps regardless of this submission by the applicants, Your Excellency. Your Excellency, I would like to call on my co-counsel to address this court on issues 3 and 4. Much obliged, Your Excellency.
Thank you.
Good day, Your Excellencies. My name is Precious Emmanuel, appearing as correspondent, and I'll be addressing issues 3 and issues 4, Your Excellency. With your kind permissions, may I proceed, Your Excellency? Much obliged, Your Excellency. Issues 3, whether the POA Act violating international human rights instruments. The applicant submits that the 14 days requirement unreasonably restricts the rights of peaceful assembly. We strongly disagree. It is the respondent's submission that the POA Act violates no international human rights instruments. Article 11 of the African Charter guarantees right to peaceful assembly. However, this right is not an absolute right. States are obliged to regulate it. It must pass 3 tests to be permitted by law. It must, the law should regulate in terms of legitimate aim. That means while regulating it, it should put the public, ensure national security and public safety. And thirdly, it should be necessary and proportionate to excellency. I would like to address this court on the fiscal character of the POA Act.
The POA Act is a regulatory framework. It is not a prohibitory framework, Your Excellency. Permission does not equate to prohibition, Your Excellency. The applicant asserts that the term of permission it violates the International Standard of Notification Standard, Your Excellency. In the UN Special Rapporteur, Your Excellency, they provided a guideline for peaceful assembly that states should use, Your Excellency. It provided that whilst giving notifications, whilst suggesting that there be need for notifications to exercise your right to assembly, you should not impose criminal sanctions and administrative penalties.
Was it notification? Was the requirement notification of permission?
Much obliged, Your Excellency. Your Excellency, it has been held in international jurisprudence and African jurisprudence that what should matter is not the language or the literal appearance, but the effect and the practical operation of that instrument, Your Excellency.
The effect of permission not mean that it may be authorized or not?
Your Excellency,
as opposed to notification.
Much obliged, Your Excellency. The guideline states that there be no imposition of criminal sanction or administrative penalties. Your Excellency, this permission, Your Excellency, does not connote to, in the fact of the case, Your Excellency, there was no, it was not said in the fact of the case that any criminal sanction or administrative penalties were given as a result of failure to obtain notification, Your Excellency. Permission, the UN Special Rapporteur, Your Excellency, did not mandate states to expressly, while drafting their statute, to expressly state permission. It's expected that this thing should apply effectively, it should be operational. It did not expressly state that it should be literal, Your Excellency.
What's the law? What's the rule in international law regarding permission for peaceful assembly?
It's that there been due notification, Your Excellency.
Not permission.
Yes, Your Excellency. And that's what respondent is trying to submit, that the applicant is misreading this statute. It should not be read literally, Your Excellency. It should be more of how it is operational in that, how this instrument is operational in that state, Your Excellency. And we see that no criminal sanction, no administrative penalties were faced. They did not illegalize any protest, Your Excellency. The applicant asserts that the notification is the international standard, Your Excellency, but they failed to take due notification, Your Excellency. The public announcement does not satisfy notification. In Oya Ataman versus Turkey, this was decided for an European Human Rights Court, Your Excellency. It held that notification, the definition of notification is the administrative communication to authorities, Your Excellency. And that was why in paragraph 11, the IGP made it known that they should take notification. This notification will follow the process of writing down the day.
They require notification or permission. Is there a distinction?
Your Excellency, we are asserting that permission should not be read literally. Instead, the court should look at how it is effective, how it is operated, how it's practical, Your Excellency. In Bogota and Hungary, it's held that
the effect in your jurisdiction. How is it operated in your jurisdiction? What does your public order attach to say about it? About this issue that we are addressing specifically?
Your Excellency, there has never been any protest that has been announced that during permission has been taken that has been rejected, Your Excellency.
And where permission has not been taken, under your act, what happens?
There is no criminal sanction or administrative penalty. There's no repercussions for failure to take this notification.
Yes, so in your view, what is the purpose?
The purpose, Your Excellency, is to give due notification to the states to set up safety measures to ensure that there's public safety and there's protection of national security, Your Excellency. POA Article 31 of the Penal Convention of
So if it is just to notify, why do they need to?
This is to set up, it is to give the state enough time to prepare safety measures so that the state will be prepared against any indulgence of violent actors.
Do you have any authority to support this position?
Your Excellency?
Do you have any authority to support your position? You cite any case to support?
In Bukta and the Company, Your Excellency, it held that the law should not be read on its label, but the effects of the law, not its label. Your Excellency,
What is the effect?
the effect is to set up, only the effect of the POA Act is just for notification purposes for the states to set up measures to protect the ensure national security, Your Excellency.
Well, Council, where do you need to look at this? The argument of the other side is that insisting on 14 days notice is designed deliberately by the state to suppress peaceful protest. That it is designed to intimidate and cow them into submission. Can you address all of that?
Your Excellency, the applicants read this literally, Your Excellency, and Article 31 of the Union Constitution of Treaty says that interpretation should be based on not only on the ordinary meaning, but also the purpose and the objects of the instruments. Your Excellency, POA, when read holistically, does not suppress, it's not a tool to suppress dissent, Your Excellency. It is just a tool to set up measures to protect and ensure national security, Your Excellency. It follows the notification standard of the international law, Your Excellency. It does not impose any criminal sanction or administrative penalties. Your Excellency, the protest, it was done during a curfew. In paragraph 26 of line 10, Your Excellency, it was done during a curfew. And when curfews are set in place, rights are temporarily restricted, Your Excellency. And there was a wild disturbance. It is unreasonable for Mr. June and Marcos to have set up a protest, Your Excellency, during the fact of looking at the situation where there was a heightened tension in the land. And it is reasonably foreseeable that bringing up this protest would have led to participants being harmed, as well as it being hijacked by violent actors, Your Excellency. And during that curfew, rights are temporarily restricted, Your Excellency. Also, the use of force, Your Excellency, was reasonable, Your Excellency, as it was held in Guinea and Cameroon, Your Excellency, was set for in an African Commission, that where protesters, they fail to take procedural requirements before coming out to protest, the states would not be held liable for intervening where violence erupts, Your Excellency. You see that there was the violent actors who were emboldened to defy the curfew. They hijacked the protest, Your Excellency. There was destruction of public property. And it is the police responsibility to ensure that there's...
Yeah, but not even the allegation. In fact, we feel that the violence erupted because of the intervention and the way the police handled the protest. They came in gun blazing, or let me say they came in tear gas blazing. And the applicants are saying that is not what they should have done. You don't come to protest shooting tear gas to disrupt a peaceful protest. That is what, escalated the matter. That is what brought about the violence. So the allegation is that you precipitated the violence. What do you have to say to that?
What should I do, Your Excellency? Your Excellency, the applicant has said that the use of tear gas was used. But you see the fact of the case that there was no tear gas used in the first place. The protesters were the ones who started throwing the stones as they saw the police. They started showing violent hostility when they saw that the police wanted to curb the violent disturbances at that moment. They were the ones who threw the stones, Your Excellency.
Can you read paragraph 12 of the compromise?
Your Excellency?
Paragraph 12 of the fact.
That was during the first protest, Your Excellency. Well, Your Excellency.
So which protest are you addressing?
I was addressing the second protest that happened at the state capital.
Okay, we'll address this one.
Okay, Your Excellency. Though this happened, Your Excellency, the state took responsibility to investigate this and punish the police that were involved, Your Excellency. And so they should be absolved of liability, Your Excellency, as it punished the state actors, the state agents, that were responsible for this menace, Your Excellency, the JJCR recommendation, Your Excellency. And it also refines the police rules of engagement.
Okay, with that remedy the violation of right that has already taken place.
They also offered compensation, Your Excellency.
Inadequate compensation, according to the facts.
Your Excellency, the state took due diligence to ensure that compensation was made at least.
Even if it's not enough. Go ahead.
Much obliged, Your Excellency.
I want to take you up on this coffee thing. So, in the midst of the coffee, notice, as you said, to hold the demonstration issues were given.
Sir, Your Excellency, I'm not really hearing you.
In the midst of the coffee, in the course of the coffee, a notice was served on the state about the demonstration. Would this ordinarily be within the purview of the Public Order Act?
Your Excellency, would you rephrase that question?
Well, okay, so there are two. There was the first demonstration, no coffee. Notice was served. It wasn't whether or not permission was granted did not make any meaning to the demonstration. They went to the state. Second instance of demonstration, a curfew was in place. When a curfew is in place, you know what happens. You yourself can explain that. And then a notice to demonstrate is served during the curfew. Are you able to distinguish the two situations?
Much of that, Your Excellency. Your Excellency, where there's a justified curfew, Your Excellency, rights are temporarily restricted at that moment to curb the violent disturbance. At that moment, Your Excellency, public order is first priority, Your Excellency.
So would you say it was highly likely that the demonstration would have been refused?
If they have applied for permission, would the permission have been refused or approved?
It wouldn't have been approved because public priority at that moment was first priority, Your Excellency. And
your time is up.
Sure, I would like to complete the indulgence of this court to give me 2 minutes.
2 minutes.
On issues 4, whether there was unfair treatment made on Mr. Jude and Marcus, is the respondent's submission that there was no unfair treatment made on Mr. Jude and Marcus. First of all, the arrest was lawful. Article 6 guarantees right to liberty, but is not absolute. Where arrest is grounded on domestic law and is subject to court oversight, that arrest is lawful, as you can see in the case of Alex Thomas and Tanzania, Your Excellency. They were before a competent court, you see in paragraph 29 of the fact of the case. They were before, and it received appellate review. In Muhammad, Abubakari, and Tanzania, it held that appellate review is credible evidence for due process, Your Excellency. Also, they were charged for the criminal offense, willfully destroying public property. And there was no form of discrimination in their trial, as the applicants have said that this was a tool to suppress their dissent, Your Excellency. They willfully started a protest despite the curfew, and knowing that it was reasonable foreseeable that there would be loss of lives and properties due to their action. They emboldened other actors to come in, and violent actors who, Your Excellency, hijacked the protest, Your Excellency. Also, they did not violate, there was no unfair treatment meted out in their trial. And we see that in the case that there was no evidence or any witness that corroborated that in at all, there was unfair treatment meted on Mr. Jude and Marcus. So it is the respondent's submission that there was no unfair treatment meted on Mr. Jude and Mr. Marcus.
Thank you very much.
violation, which means that when something is mentioned, it is to the exclusion of the other thing not mentioned. So the fact giving the president the right to ratify this treatment and does not give the president the right to withdraw this statement is still basically the same thing. That is, the president still does not, in fact, have the right to withdraw this declaration. Similarly, we are still finally saying that on issue 1, the question borders on whether the withdrawal of Article 34 sub 6 of the people of Edera violates African Charter or other international instruments. And we are saying that it still violates Portion 34 sub 7, which gave the criteria or the procedures for this withdrawal, which is said that it must be written, it must be signed by the competent authority, and also transmitted to copies for the African Union. And paragraph 5 also gives the power of the president, as earlier stated, especially units S exclusion and tutorials. On the exhaustion of local remedies, we see that paragraph 6 of the Amendment of Fact gave the Supreme Court the power to only attend to cases that is over 5 years. And the respondent came to claim that destroying public government and destroying public property is a civil case. Your Excellencies, that is obviously a criminal case. Destruction of public property does not amount to a civil case, and as such, it still falls under the realm of the Supreme Court, not being able to put or to attend this matter because the case is not over 5 years, or the fine or the probation is not over 5 years. And also on the application of author, we mentioned that the court has expanded the scope of admissibility in plethora of cases, extra charges of faculty of peace organization and federal republic, where legal entities now have the right to bring cases on behalf of alleged or people that have actually victims that have actually been infringed upon on their rights, and all of those things. Also on issue 2, the respondents focused on the EMB, the same EMB, portion to paragraph 22, to have been reported to have bribed officials to give cases on their own side. Is this same EMB that the respondent is relying upon to have conducted thorough investigation that concerns children, finding it baseless? Your Excellency, also this same JJCR that was mentioned by the respondent according to the fact accepted all of this misdoings, and then 5 months later, which could be addressed as something that's still fresh, went back to the same thing that they complained about. They also mentioned that they gave compensation. However, inviting our minds to this statement of fact in paragraph 23, it stated that, according to the report, multiple members have been moved since 2018 because of their close proximity to the mine. However, these groups are faced with similar but different persistent problems, increased challenges in obtaining enough water for daily needs, overall environmental deterioration, loss of suitable housing, significant changes in how they obtain their livelihoods, and I could go on and on and on, and the respondent still claims that this compensation is sufficient enough to cater for over 240,000 people of the Bashir tribe. Similarly, Your Excellencies, the use of force, the applicant still reiterates, and the use of force was still very unreasonable. And as such, the fact that they imposed a curfew from 6 a.m. to 6 p.m. from the statement of fact, and it shows that on that same day of protest, that these same people went ahead, the roads were blocked. If in fact that these people, the applicants, in fact protested on the day of the curfew, it's only logical to conclude that the roads would have not been blocked and everyone would have been free. But Your Excellencies, the roads were blocked, which signals that, in fact, the day of the protest was not the day of the curfew. And what protest was clearly reviewed that those protests became violent due to the intervention of the police. And the intervention of the police not just like to come and secure them or to make them better, it was to disperse tear gas. And it was still not logical or proportionate to the actions of the Bashir people. And on this we state and reiterate that on these 4 distinct issues of the applicant, the respondent, which is the Republic of Edera, should be held accountable and should be resolved in our favor.
I'm Dr. Adekule. Yes. I must confess that I'm personally impressed and the presentations of the advocacy council is quite commendable. You have done your very best, and I can tell you that if this were to be televised worldwide, you have been adjudged excellent. You have done pretty well. The understanding of the law is quite commendable, and you have been able to touch on so many few areas of the law that are quite targeted to what you are doing. You have touched on mining law, you have touched on international law, touched on international law, you've touched on environmental law, so many other areas, and I think if the council, if they are not the best, then we are the best. They have done pretty well. Thank you for your presentation.
My name is I want to associate myself with my brother. You are finalists, and ideally we should be expert. We won't say more. If this were ancient Greece, you will all be adorned with garlands and described as descendants of the gods. Thankfully, this is immortal. I mean, this is Caleb, and we know that even gods have their frailties. So the only thing I want to advise you on, apart from the commendations expressed, all of you, except maybe one, I think you seemed overwhelmed with the fact that this is the finals. So, sometimes when that happens, when you are in such a position, the best thing really is just think about what you did to get to this stage. It calms you down. Having said that, I want to congratulate both teams. You have done very well. If we have unsettled you with questions, it wasn't deliberate, it's just to prepare you. Sometimes I see some of you want to kind of give us a knock on the head. Let me continue, sir. But that is the way it is. That is the way it is. We just want to get our reasoning right. And I want to thank you for being a great help with that. Thank you.
Thank you, my Lord. Thank you, sirs. Let me join my Lord and my senior colleagues to also congratulate you. For me, it's always a joy judging students at this level of competition, because what we often see here, even some lawyers in regular courts cannot even duplicate. So for me, it's always wonderful seeing you guys perform, and I think that the heaven is your limit, and you have a very long way to go. Just a quick one about compulsion, like the learned senior advocate said. The purpose of the questioning is just to see how grounded you are, with what you are submitting. Because if you are just reading from the text, what will unravel you will be the questions. And gladly, I think all of the participants did very well in holding up. There are some hiccups here and there, but you held up very nicely. And I want to congratulate you for a job very well done. Thank you very much. I didn't introduce myself. I'm Dr. Akinola Akintayo, Associate Professor of Law from the University of Lagos.
Sorry, sir. Hello. Hey. Come on for the
grab hold of fantastic. I mean, to get to this point, you know what you have. The material the issues, as my brother here said, touched on environmental, children's rights, human rights, and so many areas, and you have held on to your own. I want to congratulate you all. You are all materials. I have judged international moot courts. I've judged at The Hague, the IBA ICC moot court. I've judged the JSO at Washington DC, and I tell you that you are excellent materials for international mooting. And I hope that I will see you on top. We have had issues of Nigerians being given visas. That has been our problem. Because when I was at The Hague, they were pleading with me to ensure that Nigerians come for the program. And you are excellent material for the bench. I want to wish you well. I mean, my brothers have said everything that needs to be said. You have done very well. I mean, sometimes it gets overwhelming, you know, the questions. But the questions are meant to sometimes assist you to push your point. And at other times, to prepare you. Because when you are at international competitions, you're going to get a lot of questions like that. It's not like our own adversarial system in Nigeria where the judge does not descend into the arena, or else will be petitions. A petition will come in that the judge is not allowing us. And we seem to have lost a lot in terms of advocacy because of the rules of court that just says, oh, adopt and go. And when you give the lawyers a chance, I want you to adopt. They say, oh, everything is in our address. So, you know, so seeing advocacy back and the front for of this, it's really very, very excellent. So I love it. So I want to encourage you. I want to wish you well. Keep doing what you can and keep improving. And you're all winners. I want you to know that. For you to get to this round, you are all winners. So very well done to all of you. We will now give the opportunity for some pictures if you want. That both teams can come up.
Both teams are the back. And then first of all, the teams for today. Please can you come? Go to the back of the judges. And thereafter, any other thing can go. Okay. The contestant should smile a bit. I mean, hey, the competition is over. Okay, good. Good. All right. Nice. Okay. The court is good. All right. Okay.
So, thank you everyone. We're coming back by 1 p.m. for the award of the check and the prize and the winner and the best oralist and other stuff. 1 hour's time. Thank you very much.
So, go enjoy yourself and then come here later. Yes. I don't know.
We are using for the award. This same thing.
Just